lawyer, what is the hurdles we have faced, our main motto is to get them not to face such hurdle here. That is the main motto. With this motto, we have started our program. So we are taking the nomenclature from Delhi High Court filing size. So one lecture or one workshop we are conducting on the civil sides, and that is on criminal sides. So today our civil side lecture, and that is injunction application and IPR matter. This is a really a growing field. If any advocates or anyone want to devote their complete time on IPR only, he can become very good advocates. That is very growing field also. So these injunctions, we have invited the 4 5 speakers, those who consented to come and enlighten us on that issue. But unfortunately, few of them couldn't make through due to either their personal exigencies or the health exigencies. Those who are present here,
the Bluetooth device is ready to pair. The Bluetooth device is connected successfully.
I the welcome today's our the speaker or the fellow speaker, Mr. Rashid Azam, AOR Supreme Court of India. Really, being an AOR is a very good achievement. And after becoming an AOR, he was always busy and he has spared his time and he came here to enlighten us on that issue. I further welcome the light of the evening and our chief speaker, our Prashant Tata ji, who is also always, even we couldn't get time to meet, even always, but yes, I'm coming here, I'm there, I'm in Supreme Court, you're there. But despite his busy schedule, he has given his consent and he agreed to become the chief speaker. And he also further agreed to enlighten us deeply on that issues. So basically, injunction, whatever is there in the IPR matters, we will be enlightened by our speakers. And before that, I hand over the mic to our one of the fellow organizers,
the
Mr.
Bluetooth device is ready to pair.
Sudhir Kumar ji, to carry forward the program. Come, sir, please.
Thank you, Nazim sir. This is our 13th lecture series in a row that we are conducting. And every time we are making initiative to take topics which are in our nomenclature of Delhi High Court. So one should understand the intricacies, the toughness, the issues that come in preparing, filing, and the most important part, arguing of those nomenclature. Because without going in the insight of nomenclature, you cannot file that particular petition over here. Now, please understand what is the topic today. This is civil suit in bracket commercial, IA, injunctions in IPR. So, we are speaking about the interim application or the interlocutory application that are relevantly applicable in IPR suits, which are duly filed in civil suit commercial category. Now, apart from IPR suit, there are 4 more categories, that is IPR, ID, then patents and trademark, including IPR. But civil suit COMM is the most important, where the initiation of civil suit commercial with IPR issues started. Now, among this, we have 3 speakers. They will discuss the issues that has dealt with them in their cases, which are marked at Delhi High Court. So I first invite Rashid Azam Sahab to please come and enlighten us on the various issues of injunctions which actually my learned friend has faced in Delhi High Court, so that It should be an advisable for us to take care of all the issues while going through injunctions. So Rashid sir, I invite you, please.
Thank you, Sudhirji. Thank you, and thank you, Prashantji and Rajanji, my fellow speakers and my colleagues and friends here. I think I'm audible. I hope so. Yes.
All right.
So nowadays, when it comes to injunctions and interim injunctions and ex parte injunctions, I'm sure you must have faced a lot of difficulty because this is a dying relief in most of the. It's still relevant when it comes to IPR suits and IPR reliefs when we come to the Delhi High Court for emergent reliefs. Why it becomes important is because this has a commercial flavor to it, and most of the subject matter may get destroyed by the time the court are able to decide and decree, even if in the favor of the plaintiff. That actually destroys the subject matter if it is not taken up in urgency. So it still remains relevant as far as commercial suits are concerned. And when it comes to IPR division suits in the commercial section, of course, the rules governing are the Delhi High Court original site rules, you know it already. But then there is a separate rule, 2022 rules that governs the IPR division suits. So there are specific rules that actually are an overlay. We must have actually read that overriding provisions or repealing provisions and so on. This is an overlay. The word is overlay. So overlay is not actually doing away with what existed before, but then it actually is a conjunct reading to aid what is already there. So normally Order 39, Rule 1, 2, 3, etc. Actually, you know, those cover the interim reliefs of injunction in suits in a traditional sense. But then when it comes to commercial suits and the Delhi High Court rules and the IPR division rules, this actually has been further strengthened by Rule 11 of the IPR division, then Rule 14 and several other rules that come in aid of the already existing provisions in the CPC of Order 13(9). Now, there are some jurisprudence that have actually evolved over the period, though IPR is not new, but then the evolution of law is recent and it is very novel. And Delhi High Court has been on the forefront of evolving jurisprudence as to evolving the law of interim injunctions while the suit or pendent light injunctions, which becomes confirmed injunctions when the suit is decreed in favor of the plaintiff anyway. So what are the three triple trusts that are laid down? That is all the traditional law. It is everyone is aware of that there must be a prima facie case, and then there should be a balance of convenience, and the loss should be caused that may be caused or apprehended should be irreparable and cannot be compensated. So in such circumstances, injunction in general is granted by courts in all jurisdictions, not only in IPR and commercial, but then when it comes to commercial and IPR division suits, it really becomes very critical. You would have seen the very disappointed where no interim injunctions are granted. We will see you can be compensated, it's a property suit and so on. The courts brush off and say, no, no, we are not inclined. The proceedings can go on, even if it's to your detriment, we will undo it and based on what the outcome of this current appeal or whatever. In the same way, it does not hold true in the case of commercial cases, commercial suits. Here, the overlays actually make sure that you, when you come to the court, you come with clean hands, you actually declare all previous litigations that you have had. Sometimes there are habitual chronic litigants who have the habit of filing suits and those are not bona fide litigants. So these are things that are seen as a declaration from the plaintiff. Once that is there, then it has to be seen whether your IPR is registered or not. If the IPR is registered, presumption is drawn in your favor, the balance automatically prima facie case is made out and a balance is automatically tilting in your favor. Then the irreparable damages in terms of the seizure. Most of the times IPR is to do with goods. Those goods are counterfeit and those have to be seized or the producer of such goods has to be restrained. So those orders are naturally passed in the very first or second hearing. That is one thing that is very light of hope, I would say, that you see in the IPR division, that you still get injunctory reliefs there. Now, there are myriad of problems in the commercial suits to do with IPD. You would actually see internet domain-based disputes, and domain-based disputes actually create all kinds of complex problems and when it comes to granting relief. Sometimes, say for example, Netflix.com comes and says, I want a restraint on Netflix.net, and suddenly the Netflix.net suddenly becomes Netflix.in, and it starts infringing on the proprietary rights of Netflix. Now they can't keep coming to the court every day filing a new case and so on. So a new jurisprudence as to injunction has been evolved by the Delhi High Court, and it has been very novel in that sense that they have actually not actually termed it, but then when we read it, interpret it, we can actually define it in our understanding. It's a dynamic injunction. It's a new thing. Dynamic injunction means it will evolve on its own. The order can be interpreted in a wider way when it can actually be seen that it actually covers the injunctory relief, and someone is trying to play with the order and trying to run away with the order, committing the same infringements. So, like the example I stated, .com is infringed in the form of .net, and then suddenly when they're caught, they change it to some other domain, but then more or less remaining the same. So all those are actually translated dynamic injunction orders, which covers any identical or similar domain names. They will all come in the ambit of that injunctory relief. So this is one thing. Besides, there are also umpteen number of violators. There may be a case of uh, a proprietor who actually has some unique good, but then there are violators, many number of violators. But then we can't just pick one or two there. So a general order, there is also a John Doe jurisprudence that has evolved from the Delhi High Court, which actually passes a general order to all infringers, and injunctory reliefs are granted to them. I think this will be too exhaustive if I keep speaking. An hour is not enough for this.
Thank you, Rajesh Saab. That was wonderful because we have spoken so good on dynamic injunction, which evolved from itself. Stage, how the petitioner or the plaintiff is getting affected, then definitely a dynamic injunction has to be passed against a defendant. Because dynamic, if it involves with effect, that means infringement is very clear. Now I pass this mic to my very learned friend, Mr. Nudin sir, will be telling us more about on the procedural aspects of injunctions, the law which involves with it, and the issues that concern the injunction at larger stage. So Nazim ji, you are the audience now.
Thank you, Shudhirji, and thank you once again all the audience here. Actually, Shudhirji rightly understood that in within law, strong in procedure, that is why he has given me that the procedural aspects. So, for the procedural aspects in the injunction suits, the first of all we have to understand that if someone is coming to us in the IPR method, first of all we have to understand what is the IPR method covers. So we have copyright, patent, design, trademark, GI, and trade relations. So before giving any advice to the clients who is coming for any one of these, we have to understand that what is this and how to get an injection and how to should be filed. So if to us any matter relating to copyrights come. So first of all, we have to understand how these copyrights belong to people. And that is one of the condition precedent to get the injunction. You have to prove your ownership. Otherwise, it is called how to this copyright, trademark, or design GI belong to you. That is the you have to prove your ownership. So you have to be very meticulous on the designing the ownership, and you have to ask, and you have to collect every documents regarding their ownership and the so ownership is there. How did you acquire the your copyright or design or your GI or trade relations there. So this is one of the main things. So first of all, if you were going filing a case along with the interim application for injunction, the first question will be there, how you are entitled to get the injunction. Entitlement is that. That is the ownership you have to prove. That I am the owner, I have the registered trademark or copyright in my name, and I am using it. Because since how long you are using that also depends upon how you are, means whether you will be able to get that injunction or not. So this is the thing. Another, while the drafting a petition and injunction, you have to see the ownership, bona fide, as well as the irreparable losses you will incur if this injunction shall not be given to you, will not be given to you. That also very meticulously you have to explain before the court. Because these things only court will ask only. How are you the owner of that and how you will lose or how you will incur the losses if the injunction has not been given to you. That things only you have to see. So now, if we see that is the what kind of injunction we can get. The injunction we can get the permanent injunction, interim injunction, mandatory injunctions. These injunctions have been given. So far, the statute is concerned, we have the specific related 37, 38, 39 sections, as well as the CPC 39, 1 and 2. Basically, these elections are going only. For especially interim election, our 39 1 2 are being preferred only. So on that here, again, there is a Mr. Rashid has rightly told that there is a John Doe is there, and Anton Pillar order is there. Two things has been evolved. Now, nowadays, still we can say. Now you have to understand what is the Anton Pillar orders. The anchor pillar order is that only. Suppose some infringer or some pirates has stored some infringed material or they have infringed your copyright or trademark or design or anything in his houses. He is not allowing anyone to enter. So in that cases, the entrance pillar orders are being issued and on camera, plaintiff is allowed to enter in the premises of the infringer and search. That is called entrance pillar order. The another is John Doe. So John Doe is the basically if you say there is the unknown, the case against the unknown person. Because in this digital world and the era of AI, what is happening? You are means definitely you won't be able to get who is in your works, either your copyright or design or trademark, wherever who is misusing it. So for that you have to keep one department to track. So here the John Doe matters are being filed. In John Doe, orders are being passed against the unknown pirates or unknown infringers. In unknown infringers, what has been done? Local commissioners are being appointed and having all the power, giving the police power to get the police also and direction to the nearby police station or the SCP, DCP or SP, whatever the case may be. They will go, if they have a reasonable apprehension there, and there is a proof there that you have put in your houses some infringed materials, or suppose some clothes you are selling and by labeling some brand. That is why you are infringing the brand name of that company. So they will go and they will seize all the material and brought before this honorable court. That is called the John Doe orders. So this is the procedural aspects. The another things the while the drafting the injunction applications, we have to show before the court the irreparable losses. So if it is possible, you can quantify it, how you will do. Suppose in some matter, suppose you are some brand. Say, for example, you are the brand of Apple or BlackBerry or some Sapphire pen is there or Mount Blanc pen is there because there is too much piracy, not piracy, infringement on Mount Blanc. Because Mount Blanc minimum pen is the 3400 and these are even getting 700 rupees. So definitely it is infringement. Maximum advocates in Delhi using the 700 rupees pen and they're showing it is minimum 3400 rupees. Yes, station to service, I think he has used it. So this is there. So if there is a and there is some Guptaji is selling there the Mount Black pen as well as the Shivaya pen only 700, 800 rupees and 1200 rupees. So one thing is that you can go and you can buy one pen. You can pay him online and you can get it. Yes, this is the pen. And then you can show it to the court and say yes, he is selling it. And then local commissioner will go there and he will see all the material whatever is there. But so far he is selling the engineering right, but so far there is no injunction on this very pen wala. So this is all about the procedures. We have to show the how we are losing.
He is on the immune territory of IPR.
Suppose so now suppose you can say there is the original Mount Blanc brand can come and show that yes, see this is my sale ratio. In 2021-22 my annual return came this and this, and 23-22-23 is this much. So we have lose this much. And due to them only they are selling this is the infringement by using my brand name. So they can ask for the rendition of the account as well as the damages. So if court find that yes, your claim is bona fide and the genuine, then definitely we get the damages. Again, another aspect is that is in North India it is there, but in the Gujarat and Mumbai it is very rampant. That is the misuse of the trade relations. I have got the several parties, although they have consulted me, but they have never given the cases. They have what? They have worked on some medicine companies or some other companies. So combination of the making the medicine, they understood that this is. They will go, simply they will leave the company and they will sell this idea to another companies by getting the millions. But here you will be getting the 20,000 rupees or 50,000 rupees per month and they will simply go. So there is a protocol in the medical companies and other those who are having the trade relations, methods are there. So in that cases, they are before employing any person in the strategic post, they are getting one the agreement signed. You cannot share our trade secrets to anyone else. But still many people are doing. And the cases are coming only. So this is also another growing aspect. So for that only, if someone is coming on this trade secrets, so here you have to see the what is my methods and what is your methods. Because in 2007-8, I listened that the Indian medicine companies are not allowed to enter in the international medicine companies conferences. Because they will come, they will up and down the competition, they will make the medicine and sell in the Indian market and they will give this only. So this is, I think, all this about the procedure, how you can get and how you have to file. For filing only procedure, you know that the site is there and you have to file it. And all these only, maintainability, there is a first, if there is a doubt in the registry, they will first ask the you explain about the maintainability, how it is maintainable, and what reliefs you ask for the which person, which respondent, and how you are entitled to get the injunction or the relief against that person. That is to be you are very meticulous while designing your application or the petition. So once you are getting the injunction only, the definitely you get the relief. So one more thing is there, see, we are filing in the civil suits also, original sites also, even in the COMM also, and as well as IPL, all the matters also. Just you have to take care of, see, the relief. Whatever you are writing inside the body of your petition or in the application, ultimate what matters is the relief. So in the main suit, the relief should not be same in the main suit's relief as well in the interim injunction relief, interim application relief. What is idea is there? If you are whatever the relief you are seeking in your main application, if you get it in the interim, what remains? You own the cases. That is why there should not be the same or the similar reliefs. If there is a similar relief, definitely court can decline. Court cannot can decline. Court definitely court will decline that. That is a settled position of law. I think this is all about the procedure of the injunction application and IPR as well as the other matter. Even in this, the bona fide and the ownership you have to see in the other CSOs matters also. So this is all about, and I am grateful to all of you for giving a patient sharing to me. And thank you, all of you. Thank you, Sudhirji, for giving me this opportunity. Thank you, thank you.
Thank you, Nazim Sahab. That was very wonderful. That you given very good insight on three kind of injunction which is usually used by Delhi High Court now. John Doe, then Anton Miller, and there is a dynamic. Because with dynamic injunctions, there is something very important thing called innovativeness which comes in the order. But what about the major laws that are involved with injunctions? What are the major judgments which are passed by the Honorable High Court describing about the injunctions in IPR issues? For that, now I invite Sri Prashant Verma ji, a very honorable and very learned advocate for Delhi High Court and having a very good standing on various panel issues. So, Prashant Verma sir, mic is in your hands, sir.
Thank you. We had a nice discussion till now, and everybody seems to be the younger one. We are in front of us. They are. I understand they are enjoying today's lecture also. And the dais, Nazim ji, Siddhir ji, and Faisal ji, and apart from that, Rashid ji. Sometimes Shivji is also with us. Today's topic, as everybody is hearing also, not only the persons those who are sitting here, I understand hundreds of people are watching this as a live program. In Delhi High Court, of late we have started a regular lecture by our consultancy group of lawyers. And each and every friends of us, they are literally helping us
The
and at the
Bluetooth
same
device
time.
is ready to pair.
It is not only to contact the senior lawyers as well as the younger generation lawyers also and mediocre lawyers, those who also come and participate in our program. They
The
enlighten
Bluetooth
all of us.
device is
And
connected successfully.
we, all of us, understands from time to time what are the legal issues, particularly in Delhi High Court. When we are filing the cases, it is for the younger lawyers. You see, the nomenclature is quite important. Today's program is on civil suit, original side that is, on commercial disputes. Interim applications are filed in the civil suits. That is interim application on injunction, particularly in the IPR matters, intellectual property right matters. Delhi High Court handles major of the IPR matters across the nation. and we have got a good number of good honorable judges as well as lawyers also of this bar who are pioneering in this field across the country, and some people are also going abroad also. While discussing on the interim applications, the preliminary point which is raised before this entire country is that India is developing. Business are at a straight. Everybody wants that my business to continue in a better way, and I must not suffer from any kind of pilferage or the stealing of kind of business. Intellectual property rights means the rights which you are talking about individual companies. The corporates, they are having the business. If they will lose their business, then ultimately it will affect to the economy of the nation, which is also equally not good. So we have to thinking on those lines. Today, what are the scenarios in the entire IPR sector is? I will be also coming to the judgments of various courts, the individual judges, honorable judges, and their feelings also on IPR matters, whether it is on trademark, whether it is in copyright, patent, design, GI tag, and the recent, the developments on IC circuits also. And the farmers side also, we have got the developments on various seeds and on developments of the, you can say that patent kind of work also.
Plant seeds and varieties.
Plant seeds and varieties, that is the act which we are also. When we look back again to our Honorable High Court, whether we are having the equal number of cases in all those enactments or not, that is also required to be known by our friends. The younger generation must also know that on what are the fields which our Delhi High Court or our High Court judges are dealing, or the lawyers have also made those matters to reach to the courts for the better business or the betterment in their business locality or community, so that they will not lose their business. In a commercial matter like this, if you have got the stake, then you have got a win-win kind of situation. If you do not have the stake, then possibly your basic civil suit is unquestioned, whether such suit is maintainable or not. As my friend was also saying that you are right on a particular issue. If I am a owner of a particular brand name or a particular thing is being developed by me, so I'll have to establish that how I am the owner of that brand name or how I am the owner of that development which is being done by me. So while drafting the petition also, we have to be quite vigilant on those issues, that how I am claiming my rights in the property. Like the civil matters, we have to also in the intellectual properties, because these are all the properties and it also deals or talks about the business of a company. I'll have to first establish my case that yes, how I am, under what circumstances I am the owner. There comes that claiming that ownership. Like the civil matters, you have to have your registration of the properties. So is the case in case of an intellectual properties, whether it is under the Trademark Act, there is a registry. In IPR on copyrights also, there is a registry. You have to have the registry from there. If your basic registry is not proper, then getting the injunction, or even if you have got the injunction, the question will arise, which is also recently being dealt, and the matter has been referred to a larger bench by Honorable Justice Harishankar. Everybody knows. I will not be telling you all that what are the exact judgments or what are the deep into those judgments. We have to also dig into those. But at the same time, we have to also understand that yes, in this manner only we have to file a petition. I have to draft my petition. If my writing is not proper, if my drafting is not proper, then I am getting the relief is also is a big question. So what is important here is that while drafting a interim application, IA, on injunctions. Our friends were saying that earlier the monotonous kind of the injunction interim application in civil matters. That is Order 39, Rule 1 and 2. Order 39 starts from Rule 1 till up to 10. Everybody knows it's not that. And if the continuity is there, you require to stop them in perpetuity also. Now the question arises under the act that is called Commercial Courts Act, that yes, I will definitely have a prima facie case. But what to if it is in a larger scale it is happening? Under such circumstances, the question of dynamic injunction comes. My friend was saying there are also having some other issues on which the courts are also going into that. But primarily now what is being the three injunctions, that is temporary injunction, permanent injunction, and then the dynamic injunction, which is a new evolution in the field of law, I understand. What is that dynamic injunction, or how we are requiring that dynamic injunction? Because somebody has done a mischief or somebody has done a great loss to a company, and that is continuing on and on.
The Bluetooth device
Even
is ready
if
to
you
pair.
are in a social media platform or in a YouTube kind of business, you are harming upon a company also. In that also recent assessment, that supposing I am having X kind of business, some goes into the public platform and started campaigning against me, that ultimately causes a loss to me. New laws are also evolving on those issues. In Odisha, we are having a small outlet, but they are having brisk business. Like you must be knowing here in Delhi, like your Rajendra Dhaba. It is having the business. But tomorrow, if some people started campaigning against a particular that Rajendra Dhaba, it is selling such and such product, it may also affect to the mind of the people, and it will make a big loss to that company. That company may not be doing that, but there will be some unscrupulous or some the person who will be harming upon that business. Small business or a big business. The person who was selling the jhalmuri over there in West Bengal in the recent election, Prime Minister visits his outlet. It's a small business, but he is going to have a brisk business. And the other day also there are people that those who are saying that so and so person was selling, not the original person was there. It's a harm to the business of that person. Younger lawyer must also think on those terms. Small businessmen should not be put into a loss so that they will hurt their, lose their heart and to lose their business. It is not that only whether it is whirlpool business or a bigger one, but at the same time we must be also equally concerned about the individual small businessman's growth. If their business is being hampered today, then it will have a cascading effect tomorrow also on various businesses. As a lawyer of the Delhi High Court also, we are also should require to be concerned about such businesses, small houses also, those who are into right kind of business. What should be the good law in future that the younger generation will take? The big organizations are there. Reliance Geo name or the Reliance name is being misused in the platform in various commercial sites, and that has been injuncted by the court. Sometimes it is not only the Reliance is having such type of difficulty, but a small company also might be also having some problem or difficulties. We have to be also quite considerate on those aspects. Then I will also come to an area. Sometimes in our court also, two companies started fighting, misusing the jurisdiction of the court, and the latter point of time, put their hand, said, no, sorry, we will having a good business in jointly. It may not be in all matters, but it happens also. Such practice are also required to be seen or to be also examined. As I understand, this honorable court in a Cadbury's matter had given a direction to both the company because they were literally setting hand for whatever business interest they may be having. But ultimately, court put a cost in a way that you have to give some chocolates of say 5 lakhs rupees. That is the order which is being said that you distribute amongst the children. Because both of them are having the business at the same time they are using the court for whatever reason. That order was there. But we have to be considerate also on those aspects. What are the injunctions and in case of such, if it is a business promotion activity also, that is also required to be seen by our lawyers when you are drafting a petition. Each and every case will have its own story, or each and every case will have a definite story of to how to succeed in the business or how to shy away it. If I am doing the business on my own, if my name is Prasanta, I am opening a Prasanta restaurant, where is the bad into it? But why I will use another name? Wow Momo versus that everybody knows that how it is. The other person could have given some other name. Why he will use such thing? Ultimately, he will come to the court. That is also that practice is also not good. We have to advise to our people also. You see, on your own name also you can have a brisk business and you can do something. The film star's name, Mumbai High Court has also come heavily on the person. In that also, Bombay High Court says that you cannot misuse the name or you cannot go into the deep state affairs of a person individuals. In those cases also, it gives rise to many issues. There are good lawyers, those who are practicing here. They have their own name also. Whether those names can be misused or can be put into badly in a manner that their videos are being produced in a way that affects their business also, or that affects their business name. So starting from the trademark till up to the business name or loss of business in a particular issue, now this IPR sector or the injunction has come much ahead. And we have to also think on all these lines. In Tata matters, means everybody must be knowing. In Tata, they have also some problem, and ultimately the Justice Manmeet Arora, she has also granted a ultimate decree also in that. Because the dynamic injunction is in a way that if several times I have been granted or I am having a right also on a particular issue, courts are time and again being granting relief to me. Despite of that, people are misusing. Despite of that, the perpetual kind of business is flourishing against a particular company and its development and the investment which is being done by that particular company. Sometimes rupees, 100 crores of rupees. It is not the individual's company's money. Ultimately, it is the public money which is being put into that company. Everybody is being, their interest is being hampered. So, after Lordship Harisankar, the issue which was involved, as everybody knows, whether a suit for infringement can be filed against a registered proprietor of a trademark for using that trademark. I am having a trademark, but others are challenging it. Law is there. You can challenge it. Once it is challenged, then what will happen to the injunctions which I have obtained? There are views in this way or that way. If you have established your ownership, then also your ownership is into question. Under the Trademark Act, how I have registered it. Deceptively similar name to everybody knows. But at the same time, I am having a business in a far off place for last 30 years. A person who stands here for last 3 years, he started claiming that I am the owner and he is injuncting against that particular company. So we have to understand deep into the entire matters and also see that how under what circumstances these laws are being also challenged and is being referred to the higher, the larger bench for such issues. And dynamic injunctions, the Colgate versus Colpal, that judgment is also there. Calcutta High Court in Lays versus Jays also, they have decided that no, because you see, Lays also, if it is a Pepsis, whatever, their business entity, they have time and again having their own taste or developing certain taste boards, and a lot of research is being put into. All sudden and done, another person will say, started copying their company's name. They are ultimately the loser. We have to think at the same time also, why you can use such name, why can't you have your own name?
I just learning one case, Starbucks versus
Net-
Starbucks.
Netflix is the most recent one which was on this.
Then on websites also. Various websites containing a Justice Tejas Karia also on adoption and use of website containing mark of Samsung authorized service center, balance of convenience, misleading consumer, irreparable harm were discussed. Deceptive apparel, Calvin Plain matter was also being discussed by this honorable court. Our honorable courts here in Delhi High Court, till up to Justice Pratibha Singh, they have done lot of work, while pool, many other issues, but on all these matters, while approaching to the honorable court, filing an interim application for stay, that is the only thing which we require to have. We have to be also vigilant about the number of matters which are being dealt in different courts by different courts and honorable judges. And while preparing our matters, we must also take into ourselves to consider that in which area we are falling into. So the drafting part is also required to be equally important. The most important aspect would be your presentation, the younger generations. How you will present your case? Which one would be my best point in this particular case? And what exactly has happened? If I can establish those points at a spur of the moment, we only have any time, but at the same time we have to be, our drafting should be so much so, brief, so that we can at a spur of the moment can point to the court that this is what I am suffering from, and I require an injunction for that. And you have read all those judgments and also the matters which are being dealt by various courts. On GI tag recently, Justice Mini Pushkarna has also dealt with a matter that is on Chile's claim of Chilean liquor. GI tag means a particular area some people are using. Like there was a dispute for Rasgulla, and the GI tag, whether it is up to the state of Odisha or is the state of West Bengal. State of Odisha was successful establishing that in Lord Jagannath temple, for there is a tradition which used to come, therefore the Rasgulla is the GI tag for the state of Odisha. So there are people, there are small, whether it may be a small businessman or a local community people, or in a larger spectrum, the nation what it is using. Chalmuri today may be a issue, political issue, but at the same time is being used by a particular area. Now onwards, maybe it will going across the country or across the world. Everybody would start claiming. Even Jhalmuri kind of preparation is being prepared by like Haldiram. Instant kind of muri they are also preparing. So on these issues also we require to have on whether on a GI tag also that is required to be seen. Integrated circuit on the last time also on ninth lecture I had said on the civil suit. The India is also growing and the integrated circuit business is also in a stride, and the honorable minister of that our infrastructure is being invested. Ultimately, structure design on the on that also you require to have a stay or injunction. You have to establish how your company is doing it, how many people you have put, or what is the investment for so and so years, because these are not another small game. Hundreds of crores rupees is being invested, and the younger generation are required to do it. It is not that always that the senior lawyers will come and do it, but the younger ones also do it. Like I today means last so many 3-4 weeks it is continuing. We are continuing in Supreme Court that Sabrimala issue. Chase Deepak is he was also of the same nature. He had started his practice from Sai Krishna. It's our truck. Delhi High Court, we can say that he is also from our place people. So we have to be, while presenting our case, looking at the Honorable Court, what is going in the mind of the Honorable Court and what exactly is supposed to be conveyed to the Honorable. In Nutella matter, Honorable Justice had put a cost of 30 lakhs on a dynamic injunction matter also. Nutella is having business for last 30-40 years. People started copying on those issues also. I have brought before a minor insight from my side. Whatever I had to convey to you, I just conveyed, and I think to your little bit expectation, I could say something before you. I'm just like you. Every day we learn, and everybody also has certain matters in this IPR cases in Delhi High Court. The younger people must take advantage of it, must go through the judgments, must go through the matters which have been dealt. It's a C, we have to do it. Thank you very much. Thank you.
Thank you, Prashant Verma sir. Want to add something, someone?
No, he is saying he is right that I had also prepared it. On public kind of thing also, when it affects to the public also, like the hospital, medicals, the life-saving drugs. Another, the hospitals also, their name is being misused sometimes. That has also come under means, the purview, and they are also taking the advantage of IPR matters also. So there are, I mean, saying no, whatever I have said, hardly I have covered, some 10-15%. But there are a number of kind of instances on which we have to, and we have to go through all those cases at least. Thank you.
Thank you very much, sir. Again, thank you for adding such good insights to us. Now, before making a thankful note to all the people who have attended this lecture series, please understand what is injunction. So, injunction starts when we ask for injunction is actually a court order, restraint, or directing a defendant to do or not. That is how the injunction actually starts. But before that, all of you might have seen, I think everybody of you might have seen Dhurandhar 1 and Dhurandhar 2. What is the infringement and what is the IPR issue involved with Dhurandhar 2 along with the three Murthy's? The three Murthy film productions, because this case is going even today in Delhi High Court. It was listed today. Three Murthy Film Productions and B62 Studios. B62 Studio is the studio that has produced and directed Dhurandhar 1 and Dhurandhar 2. And the issue was taking some music tunes of three Murthy films. That was Oi Oi from Tridev. That was a wonderful song at that, in the early 90s. But whether that song was also patented or any rights were actually registered, this is still going in arguments over there. But what is the biggest argument in this? What kind of new injunction, or not like a new injunction, but the part of dynamic injunction was asked to exempt the pre-institution mediation from this case proceeding, so that immediately the major issue should be asked for. And there is an exemption also asked under Order 21, Rule 1, Subclause Rule 4 of CPC, which is actually also applicable to commercial suits. That's why this particular section was involved is in a part of huge arguments by various seniors. If you people have time, kindly see that, because it's actually an important part of IPR. Now, before that, I have to make one important issue. Dynamic injunction also involves innovative remedies. And the very famous case in this, Swami Ramdev, Patanjali. Now, kindly note that citation for anybody, Swami Ramdev and another versus Facebook and others. And the civil suit of original site, CSOS 27/19, which was adjudicated by Honorable Delhi High Court, which calls for global injunction on GI indicators. It calls for global injunctions and inhibitors on the issues that pertain globally, not just to an area or to a country. That was a wonderful judgment passed by Honorable Delhi High Court. Now, before this, I have to say two things, because we have mostly spoken about ex parte, ad interim, and permanent injunction. We all know Order 39, Rule 1 and 2 of CPC. No need to describe that. But what is an anten pillar order? Why this word anten pillar is there? In India, there are issues of emergencies also. Why I immediately need this injunction? Why this injunction is required right now? That is an emergency. And anten pillar injunction is always read with Order 26 of CPC. So whenever an injunction in dynamic issues as involves Order 26, involvement is very necessary. Without that, you cannot get any emergency injunction. And why this emergency ex parte injunction is? Because the court allows the plaintiff in assistance of a local commissioner to search the premises, to collect the evidence, to prevent the evidence from getting destructed. And it also means that without any police order, they can go to the plaintiff or defendant area to collect those evidence. And is vehemently mentioned in Order 26 because it's actually work as a search warrant. So this is the power of injunction of Order 26 CPC. Please understand that. Then apart from this, there are severe injunctions, which is known as Mariva injunctions, very vehemently used in Delhi. When I say Mariva injunction, it immediately of financial issues like bank accounts of defendant who are infringing severely. This is also an emergency. Mariva injunction is also in a freezing order on those particular acts, products that are infringing the IP, your intellectual property rights. So its only function is to save the original creator. That word is very important. When you will save the original creator, when you will ask something which is harsh and severe. Sometimes as per your case. Then we all know about John Doe order. But what is this John Doe order? John Doe order is also known as rolling order or Ashok Kumar order. He's very right. Why? Because this order is against all those unknown defendants who are actually taking advantage of your own creations without letting you know. So such kind of order is having a ramification of worldwide or your country imaging effect. So this order is very important to understand its applicability because illegality of anybody's infringed right should be protected. Dynamic injunction is again I had told you. For that I had given this one Swami Ramdev. It's very important, very important judgment. If anybody go through it, please understand that. But definitely, what important part is when court order any defendant or any plaintiff remedies to be get prevented, we should immediately proceed for either ex parte, ad interim, or permanent injunction because these are the most important injunction, these three, whether it is going in civil suit commercials or civil suits or any part. So thank you very much, my learned friends. You all have attended this very insightful lecture series, which is duly stand by three important lecturers over here. And thank you very much that you've taken some good time to attend this lecture series. Now, after thanking you, I allow you, please invited you all for the tea and lunch series. And apart from that, I also have to tell the next lecture series for all of you, where the Honorable President of Delhi High Court Bar Association will be joining us along with the prominent speakers. And that will the topic will be the evidence, especially the appreciation of evidence. So please do attend. So please do attend that. Thank you very much for your timing. Thank you very much.
Yes, sir.
Dr. Sangwan, I'm advocate. I am basically completely against these IPR and all these rules because they are completely biased, flow given. Nobody has bothered to challenge it. And Article 21 of the TRIPS agreement, under rules you have seen, because it all they go against the